fair or not. I know it's very fair. So now I see Mr. Premier is smiling, so I'm sure he's happy. Now to my preliminary issue before Mr. Premier's argument starts. I want to raise concerns about some of Mr. Karim's language in his affidavits. We do have thick skins, but if we must call something to order, I think we should. Subject to cogent explanations being given, I find some of the language gratuitous and at times both gratuitous and sensationalist. Let us look at paragraph 9.1 of the supplementary affidavit at page 54. There, Mr. Karim says, I'm reading the last 4 lines, part of the 4th, paragraph 9.1, I said, yes. Open quote, it would be concerning in the extreme if it were willing, that is the commission, to gamble with my life or my family's life to see whether the commission's, underline this, kill rate would result in a, again, underline, hat trick, close quote. I read this to mean that the commission has killed, underline the commission, has killed 2 people, and that Mr. Karim will be the 3rd person it kills if the commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Karim have that the commission has killed 2 people?
Chair, may I say that I hear what the commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the commissions, and I say 2 such incidences, taking the correction that Commissioner Khumalo has made already, I'm just reading out what's there. So how I read it is not that the commission killed anybody, but that the commission has experienced, in Mr. Karim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the commission if that indeed caused the offenses both being gratuitous and sensationalist.
Thank you for the withdrawal and also the apology. Right at the end, in my notes on engaging with you, I was actually going to call for an apology for this. But let me conclude the debate on this aspect, subject to whatever response you may have, by saying that, yes, earlier, as you indicate, there is reference to incidents. But commission's kill rate, that cannot mean anything other than that is the rate at which the commission is killing. The commission's kill rate. You cannot, I just do not see how one can seek to change that. and that kill rate, or the rate at which the commission is killing, is going to result in a hat trick. That is Mr. Karim being the third person the commission kills. That is my reading of this, and I found it quite offensive, but you've apologized. It is the commission's kill rate. It's nobody else's kill rate. It is the commission's kill rate.
Chair, without repeating myself on the apology and the withdrawal, I would just say that I respectfully disagree with you, because I think that's a very narrow reading of that phrase in isolation, not only from the rest of the sentence, but also the founding affidavit. So if the commission can look at paginated page 11 of that same bundle, please, in the founding affidavit at paragraph 18, at the top of the page, I'm reading...
Page 11.
Paginated page 11, yes please,
Chair,
1-1. On my side, it's paragraph 18 at the top in the founding affidavit. I don't know if it's the same on the commission side. I'm getting indications it is. He explains what he talks about, where he says one of the witnesses that appeared before the commission was killed, and there was an attempted assassination on another witness who shortly took his own life. And he goes on to say, I am compelled to take these threats seriously. With all due respect, even if the commission and if the chair interprets that phrase to mean what the chair says it does, why I disagree is because at no stage has Mr. Karim ever used words to that effect to say it's the commission who's doing the killing. It's the commission's kill rate in the way in which the chair is putting it to me, as opposed to what we are saying, or what rather the witness is saying, regarding the experiences of what has happened. But I understand that the chair has a different interpretation.
I just don't see how paragraph 18 assists you, because it just refers to killings. Those may well be the killings of the commission, hence the commission's kill rate. But anyway, so I don't see how paragraph 18 assists you at all.
Well,
perhaps we should not waste any.
No, I was going to say, I think that's where we part company, Chair.
Yes,
but I must reiterate for the record both my apology and the withdrawal there.
Thank you.
On that interpretation that is put to me.
Thank you. Then let's go to the answering affidavit at page 45. Paragraph reply, I'm very sorry, yes, the replying affidavit. Paragraph 66, it reads, instead it is clear that the commission or only Mr. Popkas has opposed the application for an ulterior purpose and out of vindictiveness. I assume that the reference to an ulterior purpose is what, inferential reasoning perhaps? I assume so.
Well, I'm in front of you, so I will bear responsibility for this replying affidavit, and I'll answer you.
Actually, before you apologize, one of the things I had noted down here with regard to what we've dealt with already was who settled this affidavit. Was it you, the attorneys? Obviously, it could not have been Mr. Premhead himself, but I think you basically want to suggest that you settled it or not.
No, I am, regardless of who settled it.
But we are past that. You've retracted, you've apologized.
No, it's more than that. It's more than that, and this is important for the public watching to understand, is regardless of who said what and who settled what, I am the advocate in front of you, I am the appointed leader, and I take full responsibility for anything that causes the commission offense or upset. And as I've said, I apologized and withdrew in respect of the 9.1, I think it was. If that's what the commission wants of me in respect of 6.6, I will do the same thing. All I would point out is in that paragraph, the second sentence tries to lay out a justification for that particular reason. It cites paragraph 5.1 of the commission's answering affidavit. Now, I accept in 6.6, there's not an detailed exposition to justify the first sentence, but at the very least, the deponent is telling you what they are identifying as the basis for the first sentence. But again, I think with all due respect, I'm not going to defend the so-called indefensible. I will take responsibility for it, and I apologize to the Commission and the Commissioners, and I withdraw as is needed.
All right, thank you. Perhaps let's leave it there. And why I introduced this by saying, is this reasoning by inference? I was then going to take you to what the test for inferential reasoning is, and then I would have also asked you, has that been satisfied for Mr. Karim to say that this is being done or averred for ulterior purposes?
Yes.
But perhaps let's leave it where.
And
Yes.
may I just say, on the on that particular averment in the paragraph, insofar as the determination of the issues in front of you is concerned, that is actually not a central issue, to the extent that it's been called out and
I would have thought so
yes,
too.
Exactly.
So it's
No.
that too, in a sense, is quite gratuitous.
No.
Thank you.
But that's why I'm accepting your
Yes,
logic, and I'm
yes.
saying to you, I fully accept what you say to me,
Thank you.
and I give the tenders as needed.
Thank you. Let's go to your 30 minutes
Okay,
then.
yes,
What's the time now?
I'm familiar with that 30-minute of grace before the barrage of questioning starts. So is Mr. Kumalo. He argued a few days before me when I was there for Pala Pala. But, Chair, may I say this? I think that
I'll give you until 13 minutes to 12. You may start.
Chair, I was going to say that in light of what has occurred for most of the morning, we had prepared a note on argument which I was going to have regard to, but I think that has largely been overtaken. Instead, I intended to structure my submissions to you in the following ways, if I may. I'm going to deal with 4 topics very briefly. Firstly, is I'm going to address why we're here. Secondly, I'm going to address the questions put to me by Commissioner Kumalo. Thirdly, I'm going to refer you to some cases on what I think are trite propositions in scenarios like this. Lastly, I'm just going to make some comments about prejudice. So, at the outset, and we've already debated 4.2 and 4.3 in the morning, the simple proposition is this: it's not the evidence itself, and Commissioner Baloy actually identified that there's a distinguishing feature about this application and how it was brought and when it was brought in respect of other applications, and I adopt that analysis because that's the very point that I want to start with. It's that it's not the actual evidence that my client gives which brings us here, but rather the fact that merely by appearing here on the 6th of February as a confirmed witness who was then granted a postponement and which gave rise to the 4 or 5 threats that we've attached to the 2 affidavits, which don't only threaten my client individually, but also threaten his family, that threaten the burning down of his businesses, that threaten them if they even leave where they were originally located, it wouldn't matter, because where they would potentially be moving to would also be known. And I'm trying to use language so as to not give away geolocations. Those are the serious threats that bring us here. So the reason for the in-camera then is, and I say this with all due respect, the reason for the in-camera is the threat to the life of the witness, his family, his businesses, and his economic interests. And that is not contingent on our reading of the rules of the actual evidence to be given in chief by that witness themselves, because nothing in the rules makes the application for an in-camera hearing contingent on that evidence in and of itself. I'm willing to accept for the sake of debate that it might be a factor that the Commission takes into consideration in deciding whether or not there should be an in-camera hearing or there shouldn't be an in-camera hearing. But what I will say in that regard is that that factor is but one factor in the basket of factors. And what else is in those basket of factors, in other words, in addition to the evidence that he's going to give, is the existence of those threats, the way in which he has treated it seriously, and reported it to the police because of the seriousness involved. And I must say this, the Commission, in response via the answering affidavit, starts out the answering affidavit with saying, I have some sympathy for Mr. Karim, but, and then goes on to say why the in-camera should be refused. And with all due respect, those reasons as to why it should be refused are reasons that we in fact rely upon in order to justify the in-camera. So those reasons that are relied upon by the Commission are inter alia the following. The first thing the Commission says is that the applicant has already been the subject of national media coverage, that his identity, appearance, and scheduled testimony are already in the public domain, and therefore the consequence of that public knowledge is that, well, an in-camera hearing is going to be pointless because everybody knows. But the truth of the matter is that if the in-camera relief is granted, then everybody will not know. Yes, they would have known what the arrangement was for Mr. Karim to give testimony in an open session was, but they won't know what actually occurred thereafter if he doesn't give testimony in the way, in an alternative way, if the in-camera application is granted. So, with all due respect, the Commission's position that this has already been in the public eye is the very reason that we come to the Commission, because you will know we say that these threats have started emerging even before he's given the evidence. So it means that the people who are threatening my client don't know what he's going to say, but they are so aggrieved potentially by whatever it is he's going to say, that they're already making the initiative to threaten him, his family, his businesses, and his employees, as well as his economic interests in the way that it does. The second thing that the Commission says is that, and it's a line of argument that is rooted in open justice principles, and indeed in the morning, I think it was potentially the Chair and Commissioner Baloy who put it to me when they said, I thought, or used words to the effect that I thought he would want to come and give this evidence in open so that that everybody knows what's going on. But with all due respect, that argument again makes the case that we are applying for, and that is that this publicity, without the threateners even knowing what it is he has to say, are already threatening him. If he comes here, it's almost like waving, and that is not made subject to an in-camera ruling, it would almost be like waving a red flag at a bull and waiting to see whether or not the bull charges and gores you, and effectively to take your life into your own hands. And the reason I say that, and mindful of what the Chair has already said regarding those particular paragraphs in the replying and the supplementary affidavit, is that the Commission itself does not say these are fictitious, these are non-credible, these are made up. They seem to accept, at least at the surface level, that these threats are real. And so the question then becomes for the Commission, bearing in mind, and the Commission and the Commissioners, bearing in mind that you have an applicant in front of you who says, I am scared, I am fearful. Does the Commission and the Commissioners turn a blind eye to that in circumstances where no one has suggested that those threats aren't real, aren't credible, aren't serious, and don't deserve to be taken as seriously? So that's point number one about why we're here. We're here because of the fact of the threat, and any opposition mounted on the content of the main witness statement, I would submit, is firstly misplaced, but secondly, to the extent it's not misplaced, it's but one factor in the basket of factors under your consideration. The second topic I want to talk to is the topic, is the question put to me by Commissioner Khumalo. Commissioner Khumalo, you took me to the Schedule A, and you had indicated that the schedule was problematic because it excluded certain people and, you know, was perhaps too restrictive in terms of the people that it did include. And you mentioned particular individuals like the head of the security, the investigation team, the researchers, and all these categories of people. I'm willing to accept that this might be too constrained, and the reason I can readily accept that is because we simply don't know who the relevant people are in the operation of the Commission behind the scenes. Likewise, for example, in trying to get the application in front of you, we don't know how long it took when the Commission's attorneys received it to put it in front of the commissioners, whether it was placed in front of you before the 25th of February, whether the correspondence bundle, like we asked to be placed in front of you, was placed in front of you. We don't know all of these things. And the reason I highlight that...
They're in the website, Mr. Freeman.
I beg your pardon?
They are in the Commission's website.
Please continue, Mr. President.
Be that as it may, it can be on the Commission's website, it can be stapled outside the Commission's premises. The point of the matter that I'm making, Commissioner Khumalo, is that parties often ask courts for relief all the time based on what they understand the position to be. And sometimes a court will say to them, as you will well know, yes, you've made out a case, but this operative part of your relief is a bit too narrow or a bit too broad, and we need to include these people and we don't need to include those people, or whatever the case is. So, with all due respect, if it's a question of the schedule, we can amend the schedule. Or if it's a question of the Commission making a directive regarding who should be included and who shouldn't be included if the Commission is with me, then that satisfies the issue with all due respect. Because like I said in the debate in the morning, and I think it was with the chair, is that these requests have always been subject to the chair making the appropriate ruling, either accepting and granting the application, or dismissing the application, or granting it but subjecting it to different grounds on the relief, or anything of that kind. So I think with all due respect, it's a little bit difficult for me to answer the way in which the question was put at me in circumstances where it's being positioned potentially that Mr. Karim is dictating these things. It's Mr. Karim saying to the Commission, I'm asking you for these things based on what I know at the time that I know it, and I lay myself in the Commission's hands as to make the ultimate determination. So if the accuracy of the schedule is incorrect, we wear that. And we wear that not because we want to keep some people out or some people, we simply don't know. And that's why we come to the Commission and ask for the relief that we do. May I go on to my third topic? And I think, Chair, I'll be done with my protected time relatively soon. May I just take an instruction? Yes, and I'm just being pointed out that the particular paragraphs that Commissioner Khumalo had difficulty with was 3 and 4. I think what I've just addressed is the difficulty with paragraph 4. Regarding the difficulty with paragraph 3, I just would point out that it's not the main statement that was subject to the in-camera, it's the in connection therewith defined as being in the in-camera application. And I mean, even if the drafting is not clear enough to make that clear, let me make this clear now on the record, that must obviously be the case, because if the in-camera application that we're arguing now is unsuccessful, then the normal rules apply. But if the in-camera application that we are arguing now is successful, that would be subject to whatever the Commission and the Chair ultimately grants as the relief. And again, I understand that the concern against me might be what it is. I don't think that the idea has ever been that the main statement must be kept away from the relevant commission staff. It must be kept away from it being an open publication, or as effective as an open publication. That's the contention in the in-camera. And in regard to the Brown-Mokhotsi example that Commissioner Khumalo raised, apart from saying that I don't know whether Mr. Mokhotsi applied for an in-camera hearing or an in-camera hearing and how that would impact fair trial rights, like I said in the morning, part of the Commission's imposition of an in-camera regime would make accommodations, as it must, for these kinds of issues to be ironed out. So that, like we know, for example, in high court proceedings and in all court proceedings, where there is a confidential affidavit filed, sometimes what the court says is it seals that part of the record, and the parties are given a full opportunity to engage each other on the contents of that confidential affidavit. It's just that those exchanges of affidavits are subject to a confidentiality regime. And we don't ask for anything more than that. And in fact, we ask the Commission, if such an in-camera regime is going to be upheld in these circumstances, that that's the kind of consideration that is applied. May I say then, on the third topic that I had, which was about the cases that I wanted to deal with, I think these are fairly trite propositions that I'm making from the cases that I've cited. I've given my learned friend notice of those cases and the paragraphs that I'm going to rely on. So I'm not going to ambush her very deliberately. But my learned friend raises her eyebrows at me. But these cases, we say, put forward two propositions. The one proposition is that the state has a positive duty towards citizens to protect them where there is a concern about their rights. That is derived from cases like Carmichael, Carmichael, I apologize, I always say Carmichael, Carmichael, at paragraphs 44 and 45, and the court will be familiar with Carmichael. And then the other case that we rely upon is the SCA case of Van Devenboden, which the commissioners will also be familiar with, and the paragraphs there are 20, 21, and 22. Now, why that's relevant, of course, is because we say that on the facts of this case, there is a threat to the right to life, security, integrity, family, commercial interests of the witness. This is a body that exercises public power in the name of the state. And so this commission is caught by the same obligations that the state has to make sure that where issues of safety are raised, that it properly applies its mind and discharges its power in accordance with that. The other two cases, sorry, I said 4 cases, there's 6 in total, and I'll come to the other 2 shortly. The other 2 cases that I want to refer to is the Constitutional Court matter of independent newspapers, otherwise I think commonly referred to as Masetla, at least that's how I know it. And the paragraphs there, the relevant paragraphs there are 42, 43, 44, 45, 58, 59, 60, and 61. And the other case that I would refer to whilst I'm talking about Masetla is the SABC versus NDPP case that came before the Con Court. And I think that was, I speak subject to correction, but I think that might have been in the context of Van Breda and whether or not his criminal trial could be subject to publication. And the paragraphs we rely on there are 28, 29, 30, and 31. And what those cases make abundantly clear is that courts in those contexts, we say courts, it applies as equally as against this inquiry as a tribunal, must engage in a balancing exercise where default positions of openness, which is what the default rules of this commission envisage, conflict with competing and contesting rights. And where those competing and contesting rights are put before the court, and this relates to what I was saying earlier about one factor in the basket of factors, the court will seriously apply its mind to circumstances where it treats openness by default not as an absolute principle, that there are justifiable circumstances where it will derogate from openness as the default principle, and that those require then the application of this balancing act. And we say that some of those factors that need to be included in the balancing act are those cases, are the instances where my client comes to the commission and under oath tells you about the threats that he's facing to life, limb, property, and family. The other two cases, if I may, whilst I'm machining through this list, is MIDI television. I apologize. I think MIDI television was Van Breda. I said SABC versus NDPP was about Van Breda. But MIDI television, which the tribunal will be familiar with at paragraphs 19, 20, and 21, and the other older constitutional court case of Mamabolo, which, if I'm not mistaken, was written by Justice Crickler, and the relevant paragraphs that we rely on there are 41, 42, and 43. And what we say those two cases give rise to, again in the context of discussing the openness by default principle, is that firstly, no single interest, this is from Mamabolo, no single interest overrides others. So yes, just because this commission might have an interest in an open justice style of argument, that justice must be seen to be done, does not mean that that is judged in isolation from competing interests where security of the person is concerned and so on. The second proposition that these cases give rise to, which is from the MIDI television case, is that the restrictions on publication are permissible where it's demonstrable that there is substantial risk to justice or to other constitutional interests. And we say that we fall into that category. We fall into the category that there is substantial risk to constitutional interests, and that's why the in-camera application, in the way that it is brought before you, is entirely justified. Chair, on the last topic, if I may, the topic of prejudice, I did address some of this prejudice in the morning at the so-called prejudice being at the hands of the commission, and I'm not going to repeat myself there. Instead, all I'm going to say, Chair, and you will recognize this not only from having deposed to the answering affidavit in the unsuccessful urgent application, but also when we were in front of you in the postponement application, that my client's complaint throughout his involvement in this commission's proceedings is one about consistency, fairness, and procedural and substantive rights. Rightfully or wrongfully, that's his view, that he is being treated in a way that is prejudicial by the commission, and in fact, what is happening is rather than the commission seeking to cooperate with him and his reasonable requests, like, for example, receiving the proper 10-6 notice, like, for example, receiving the bundle in good time, like, for example, receiving an undertaking regarding the confidentiality of the statement in good time, like, for example, that an expedited application which is sought to be determined before a deadline is approaching is placed before the commission, doesn't seem to happen. Those are the head notes, if I can use that phrase, of what my client claims as his ongoing prejudice in these proceedings. And I mention that prejudice because it's regrettable that we find ourselves in this position. Unfortunately, the way in which my client seems to be treated is in an adversarial manner rather than what we understand a role of a commission of inquiry to be, as being an inquisitorial manner. And unfortunately, the way in which things have unfolded in front of this commission have meant that, I apologize, someone is trying to phone me again. The difficulty that my client has is that rather than reasonably being accommodated so that he can come to the commission and give the evidence and do his inverted commas job and get out of the commission as soon as that job is done, instead we get tied up in these kinds of procedural skirmishes where at the end of the day, like for example, on the issue of the bundle, which was the subject of the postponement application, the bundle eventually was given, a specific bundle was eventually given the night before we were expected to appear for the first time. And why I highlight that prejudice in the context of this ongoing dispute we have in front of you is that in the absence of any credible basis to say that these threats are not real and not serious, we would say, and I say this in a guarded manner, that it's heavy-handed of the Commission, with all due respect, to oppose the application on the basis that, it's already been publicized or whatever else it is they say. Because at the end of the day, if the in-camera application is granted, this Commission will still be able to do its job. And it's important to say that because the in-camera application at various times is treated as though it's an act of gamesmanship, which it isn't. It's a legitimate request under the Commission's rules for protection from the Commission regarding the giving of that evidence so that my client can do what my client needs to do because this Commission has asked him to do it. All we would say is that when this Commission brings my client in front of it to give such evidence, that it does so in a manner that is suitably sensitive to the threats that he faces and gives appropriate relief to protect him in light of those threats. Might I take an instruction? Just whilst, before I yield the floor, so to speak, just one thing that we are aware of. Obviously, whilst we sit here, we expect the Commission's supplementary bundle, which we anticipate to be given today, because it's 2 business days later after the filing of the statement. We hope that that will be done, because that will again help my client come and do his job, rather than end up in another procedural skirmish about whether or not there's been adequate time or inadequate time. But Chair, those are my remarks in my protected time, and I yield. Thank you.
Thank you, Mr. Premhid. Just on the last point, Ms. Hassim, I assume that if that bundle is not ready, you will move mountains for it to be served today.
The bundle will be provided today.
Thank you. Thank you. Mr. Premhid, you, quite early on, you made a, maybe let me start right at the end. I'm not sure that I follow your submission on the relevance of what you referred to as head notes on prejudice to the determination of the in-camera application. I'm not sure what the relevance of those head notes is exactly. You did explain it, but I still remain in the dark as to what you suggest the relevance is.
May I respond? Thank you, Chair. No, I accept what you say to me. What I am using those particular examples of is, in each instance of those examples, my client has asked for a reasonable accommodation, which has been refused. The response to that has then been that my client has to, through its legal representatives, litigate quite aggressively, whether in court or in front of the Commission, with interlocutory applications, to have that reasonable request, firstly, reasonably considered and then decided. And I was linking that pattern of conduct to the opposition that is being put up here, and I explicitly detailed those grounds of opposition, the publicity, the fact that it's already known, but importantly, there's no counter-argument as to the credibility of the threats, that in those circumstances, the Commission insisting that my client be made to give the evidence in an open session where those threats are highlighted for determination is a further instance of the prejudice that my client finds himself in. That's the extent I was using it.
I trust, though, that the suggestion is not that the in-camera application will not be decided on its merits.
No, not at all. I know for a fact it will be
I just-
decided on its merits.
I just wanted
No, it's-
to be sure in my
I-
mind
no,
what exactly you mean by that.
In fact,
submission.
Chair, if I may, I think the way you've put it to me crystallizes the exact point. It's that in each of those instances that I've spoken about, my client, to use your phrase, has had to move mountains to try and clarify his position and get certainty and outcome. And this in-camera application is yet another example of that, in circumstances where my client not only said on the 18th, a week before, he asked for an outcome by the 25th, bearing in mind that the 27th was the due date. He also said, just determine this on the papers expeditiously, so we don't have to take up the commission's time and I know what I need to do. So I fully agree with you, Chair. It must be decided on the merits, but the fact that we've had to repeatedly move mountains to get that determination, and even in circumstances when we ask for an earlier ruling, is the exact prejudice that my client relies upon. Thank you, Chair. I'm indebted.
Thank you. Now, let me take you to something you said quite early on, which is, and I hope I will not mischaracterize what you said. You said that applications for in-camera hearings, or rather this application for an in-camera hearing does not hinge on the evidence Mr. Karim is going to give. Even though I cannot think of ready examples, I'm willing to accept that that may be so in some applications. But what exactly do you say is the basis for your submission in this particular application? I'm asking that in this context. Not every and any witness that has testified before us has received threats. And those that have either received threats or had a reasonable basis to believe that their lives were at risk, even if they had not received threats, gave us cogent reasons for us to understand why there would have been threats and why there would have been a reasonable belief that there was a risk of bodily harm or even a risk of them being killed. Something cogent was placed before us. Please bear in mind that here, I'm not talking about just the fact of threats. I'm talking about what underlies the threats that we are told about. That's where my focus is. Now, on what basis would Mr. Karim, I know the threats don't come from him, and he says in so many words in his affidavit that he does not know where the threats come from. But if he sits down and applies his mind in the light of the testimony that he's going to give, who does he think may possibly be threatening him? He is best placed to think about that and possibly to even come up with answers to that. Bear in mind that I say in all without exception, all the other cases where applications for in-camera hearings have been made, we were given something cogent, which had a factual foundation.
Thank you, Chair. May I respond? Chair, on the first point, where you said, you put to me the not hinge proposition, and you said it may be so. Just to emphasize that, our position is that based on the Commission's rules, that doesn't seem to be the case to us. But let's leave what the rules may say or not say to one side for the moment. The not hinge proposition comes from the fact, like I just read back to you in Mamabolo, it's a weighing up exercise. And so in...
I'm not there yet. I'm not I am not at Mamabulo in that weighing up exercise, because you raised the weighing up exercise in the context of open justice. So I'm not there yet. I'm just at the level of possible facts,
Yeah.
the possible basis for threats.
I'll come to that last.
That's where I am.
I'll come to
I
that
don't
last.
quite see how the Mamabulo balancing exercise, the open justice principle,
Yes.
I just don't see
May I
how
develop
that-
the submission?
how the relevance of that is to what I'm raising.
May I develop the submission? And I
Yes,
will come
yes,
to those very
yes.
point about the facts that you put to me. I'm sorry if I'm taking the circuitous route. The reason that I start at Mamabolo is because it speaks to the court's discretion in weighing up issues in front of it when there is a counter consideration to the default position of open justice. So insofar as where I anchor my submission, that it's not exclusively contingent on the content of the main witness statement, is derived from the Mamabolo principle, buttressed by the MIDI television principle that talks about we derogate or we depart from open justice when there are credible threats and so on. So I'm willing to accept.
I'm exactly at the credible threats.
Yes, I'm coming.
I think that's where we should
Yes.
be before we get to the balancing exercise. Show me the. I'm just asking you a question, and I'm not suggesting that the threats are not credible.
and I'm not
All I'm
suggesting that
saying
either.
is, what is the possible grounding, and that will then help us
Sure.
determine the question of the credibility
No.
of the existence of the threats.
I-
That's where I am.
I accept that.
Yes,
I accept
yes,
that.
yes.
But I think what's important is where I started out, because that sets the ground rules with respect as to what discretion the court is being asked, or I apologize, I keep saying court. I look at you, ADCJ Madlanga, and I go back to a different time and different place. But Chair, it's about what discretion this inquiry tribunal is being asked to exercise. And that's why I start with both Mamabolo and MIDI television, because it says that yes, you consider openness, but you consider all the things on the other side of the T account, if I can use that phrase. Then let's go to the examples that you gave me. This is now the facts and the credibility that you were talking about. Those examples, from my understanding of what you have said, Chair, is that they were all anticipatory explanations for why in-camera hearings should be justified, because if I get your words wrong, Chair, please correct me, but you said something to the effect that those witnesses who asked for in-camera hearings gave cogent reasons for us to understand who would have threatened them or where those threats could have come from, in anticipation of asking for in-camera.
Or even where they would come from. In
yes.
regard to those witnesses
Yes.
who did not say that there had in fact been threats.
No, so you and I are ad idem on that. And I would say that my client is, with all due respect, in a stronger position than those people. Because what my client says, or does, is he doesn't come to the commission on the basis of reasonable speculation about what threats I might face or where those threats may come from or who may be giving those threats. My client, by contrast, comes to the commission with real threats annexed to the affidavits and says, look at what I'm being subjected to. Now, yes, it might be that my client is being criticized for not doing a further exercise in the way the other witnesses did, in answering the 5 W's and the H, where did it come from, when, who, and all those kinds of things. But look at what my client does. Apart from coming to this commission to ask for the in-camera relief, he goes to the police and says, investigate this, and he lays a criminal complaint on the basis that he has received these threats. So, again, going back to the Mamabolo MIDI television framework I was talking about, it might be that the failure to address those questions weighs as a factor in the basket of factors against granting the in-camera application. But I would say, with all due respect, imposing that on my client and doing so in an adverse way in the balancing exercise is contradicted by the factual position that he's in.
I'm still not at the balancing exercise. I'm still at the level of the facts and what would, where, put it this way, who would these threats possibly come from? And I repeat that I'm saying,
Yep.
Mr. Karim is best placed to
Yes.
scratch his head
Yes.
and come up with ideas as to who these threats might
Yes.
might come from.
Yes.
And I'm raising this because this is going on the 9th and 10th. This is going to be his testimony and his alone. He knows what he is going to say, against whom, and who therefore might possibly want to threaten him not to say whatever it is
Yes.
he might be minded to say.
Yes.
It's on that basis that I'm raising this.
No,
Let me just, I'm not saying I do not believe him. It's very difficult to say that I do not believe him when there is no affidavit that says, Mr. Karim, you are lying.
yes.
But sitting here, looking at what he says,
Yep.
I want it to make sense to me.
Yes.
And I'm saying part of what would make it make sense to me
Yes.
is possibly who he thinks
Yes.
might threaten him.
Yes.
Do you understand
No,
where I'm coming
we are
from?
at Eden.
And this has nothing to do with the balancing exercise. I'm purely at the factual level.
Yes. I mean, I think it does come to the balancing exercise, which is why I started there. However, I understand what you're putting to me, Chair. What you're saying is the sufficiency of the explanation regarding the possible source of those threats is missing from the affidavit. And to the extent that that is missing from the affidavit, that may be something which, if you had, would have made your decision maybe easier, but now that you don't have it, makes it a complication for you in terms of how you apply your mind to the relief sought and the outcome. I understand us as being engaging on that sufficiency explanation, not whether the threats are credible or not credible. I see your microphone is on, Chair.
I know you are good at reading gestures.
Yes.
You would do that at the Constitutional Court all the time.
Yes.
and even address the gestures in your argument. I'm not sure that I want to get there. That is, get there to the extent of saying,
Okay.
I'm 100% saying there's no issue with the credibility. I'm not there yet.
Yes.
I'm actually testing the credibility in wanting to find out who could possibly have
Yes.
threatened
Yes.
Mr. Yes. I'm quite mindful that we are dealing with an application that's on affidavit.
Yes.
And, I don't even think we get to plus and evens here because
Yes.
there's nothing countering
Yes.
or seeking to counter. I realize all of that, but it does not mean that we cannot engage at the level of, is this something credible just on its face? That's where I am. And as part of that engagement, I want to know who Mr. Karim thinks may possibly be threatening him.
Well, I can't give evidence from the bar, and I'm not going to give a version on behalf of my client, whatever he might have told me in consultation. I don't know what you're showing me. In consultation. So I now, in front of you, I can't give you that explanation. What I can accept is that that explanation, in the way that the chair is putting it to me, is something that should have been there or might have been preferable if it was there, and I accept that it's not there. And what I am saying to you, Chair, is that even in the absence of those particular averments being made, that does not on its own undermine the credibility of the threats as they are evidenced on the papers. And as you yourself, Chair, have said to me, no one says in response to those threats, explained as they may be, Mr. Karim, you are a liar, Mr. Karim, these are invented, Mr. Karim, you're just wasting our time because this is a gimmick from you. So what I'm saying is I'm confronted with the position where the chair says to me, these questions might have been, or these issues, if they were addressed, might have been preferable. They're not addressed in the papers. And I'm saying in that circumstance, it is it is what it is and that we can still seek the relief. But I don't know, and I'm speaking without an instruction, but I don't know if these are the inquiries that the Commission is interested in, which again, without rehearsing anything about prejudice, if we weren't treated adversarially and if we were treated perhaps a bit more reasonably, we could have been advised about or told about. Because remember, we're also making the application on the strength of the Commission's rules where these kinds of issues, yes, they might be raised by the chair, they might be relevant, but they're not specified in the rules. So my client is again caught between a rock and a hard place where he looks at the rule, he does what he thinks the rule says.
On that point about if perhaps an indication had been given, would a supplementary affidavit assist?
I was just going to come to that, and I was going to say that's what I was going to say without an instruction.
Yes, Mr. Prem.
I was going to say, Chair, that that's what I was going to come to regarding a without instructions submission, was that given that position and where we are, a supplementary affidavit dealing with these issues pertinently may be relevant for the chair and the panel to consider. But of course, that might have consequences in terms of my learned friend, and obviously mindful of your judicial role, you will say to me, but now you're supplementing after you file the application and you're trying to remedy after the fact. I'm just tendering this as a practical or potential practical solution to the position we find ourselves in, which is if those are the kinds of questions that the commissioners are interested in, then my client should probably file a supplementary affidavit addressing those questions.
The fact that I raised it does not necessarily mean that that will be granted.
No,
it's
absolutely.
something that will be considered. Yeah.
Absolutely. But that's why I say you might punish me for not having that there at the beginning. So I'm expecting it on both grounds.
I don't think we would be that strict. There's a whole lot of things that apply in court that do not apply here. For example,
I agree, Chair.
The nature of the evidence that we may admit here.
Absolutely,
but, all
Chair.
right, let me go on. You see, my difficulty, and which is why I'm engaging you on this, is this. The threats from where I'm sitting appear to come out, like a bolt of lightning, as it were. No factual foundation whatsoever. They just poof. But there are threats,
yes,
and there's no explanation on their possible source.
Yes,
we've engaged on that.
Yes,
I'm just explaining why I'm engaging you to the extent I'm engaging.
Yes,
that's just to explain. And they seem to just come out of the air, as it were.
But Chair, that's the exact dilemma my client faces. That these threats do come out of the air. And that they're coming from numbers, and he says under oath.
And something I forgot on the last point I made. There are witnesses who before us were under circumstances that are not comparable at all to Mr. Karim's situation. Not comparable because they were in far more serious situations. Situations in terms of the testimony that they were to give and ultimately gave could possibly expose them to the risk of bodily harm and even death, by far. So on the face of it, simply no comparison from where I'm sitting with Mr. Karim's situation, which makes it difficult from where I'm sitting to understand where on earth these threats could possibly have come from. About 2 weeks or so, we had an IPID investigator who testified openly here. I know that the facts of one case cannot necessarily be used to determine another, but I'm just showing you this to try to make you understand why I have difficulties with threats that appear to come from nowhere in the sense of a proper grounding. That's where I am. That witness testified here, and she told us in graphic terms the risk that she was and continues to be exposed to. And she was brave enough to sit there and testify openly before us. So, as I say, I know at the risk of repetition, I'm saying, for myself, I want to understand who could possibly be threatening Mr. Karim, who is, at least at face value, unless there's some explanation, does not appear to be in a risky situation at all. The risk that we see comes from the unexplained threats. Any response to that?
Yes, thank you, Chair. May I just say that had my client, and I need to speak very carefully because there are things that have been said to me which are not in front of the Commission, and so, but, you know, we're coming pretty close to discussing that, so I just need to give that caveat, if I may. Had my client known, or reasonably known or suspected, one would have imagined him to say these things. And he not only says to you about the unknown numbers and doesn't give an explanation who those potentially might be under oath to the Commission, he gives an equivalent statement to the criminal case where he's opened a criminal complaint and says, this is all the information I have, here's the threats, please investigate because it's threatening me. Now, I don't want to be impertinent, but the police are hopefully not going to turn around to my client and say, no, sorry. We're not going to investigate these threats despite the objective evidence of these threats because you didn't do your own forensic exercise as to who it may be or what.
I don't think the two are comparable. And,
No, but
please, yes, okay, let me not gag you.
The point I'm making is that even an imperfect complaint to the police can sustain a criminal investigation. Obviously, we are in a different scenario here, but the point that I'm making is that it's the fact of those threats in the criminal scenario that would trigger a criminal investigation. It's the same facts and of the existence of those threats that are placed before the Commission by the witness who gives the fullest explanation. And the Alice in Wonderland world we're potentially heading towards is that my client will be refused relief on an insufficiency ground potentially, but the same insufficient evidence when placed in front of the criminal case or the police might result in an actual criminal investigation. So the dilemma for my client is that through the engagement with the chair, it's that lack of forensic exercise that he was supposed to do that is now coming back to potentially prejudice any relief that he could seek. But surely the question should be, if he knew who these people were, he'd say it. Because like the Commissioner is putting to me, those would be weighty factors as to whether or not to grant the application. But then how do you expect the witness to engage the hypothetical counterfactual of who it could be in circumstances where on the facts in front of you, they tell you they don't know who it is? And I'm not saying that the commission is expecting my client to go down the world of speculation, but what must my client speculate about where he says, I don't know these numbers, I don't know what their connection is, and must he invent a potential connection between, and I ask that rhetorically, of course, I'm not saying he must invent, I know that the commission is not saying that, but I'm putting the proposition, must he invent that connection in order to get relief in front of the commission? So that's the danger with where we're going down with respect regarding the sufficiency explanation. May I just make two points in response to what the chair has just put at me, and then I will yield again. So that's why, with all due respect, what other witnesses did or didn't do, and whether they were brave enough to sit in an open session or not brave enough to sit in an open position is actually immaterial. And it's immaterial because I don't understand the position to be that you need to show a quantifiable level of harm to try and trigger this kind of relief from the commission. It's rather whether if we use interdict language, for example, there's a reasonable apprehension of that kind of harm. And in these circumstances on the facts, what we can't run away from, even with the evidence being as insufficient as it might be, is that the existence of those threats are on the table in front of you, and that grounds the reasonable apprehension, given that those are real threats, to seek the relief in front of you. So I fully accept what the chair says to me, but that's really the difficulty that I'm in, and which is why I will gently mention the supplementary affidavit again, if it should help.
One last point from me. I hope I'm not articulating this out of context. You said something like, the people threatening Mr. Karim do not know what he is going to say. Wasn't that part of the submissions you made? I do not follow the basis of this submission. Is it not more likely that people that would threaten Mr. Karim would be people who have somewhat of an idea of what he may say, and therefore would threaten him exactly because of their belief as to what he may say? So I don't quite follow your submission.
Yes, what I was pointing out was just the factual timetable in which it arose. So it's obvious, well, let me not say it's obvious because stranger things have happened. We assume that Mr. Karim is not just going to be subjected to threats by anybody, right? We can assume for the sake of our engagement that Mr. Karim is going to be subjected to threats by people who potentially know what they think Mr. Karim is going to say or not say, and how that might implicate or impact them. All I was saying in respect of what you put to me, Chair, is that before he then even comes and says whatever he might say, he's the subject of the threat. So why I mention that is because it demonstrates, with all due respect, that whoever these people are, and whoever they may be, and whatever the connection they have to Mr. Karim, direct or indirect as it is, are taking this kind of hostile attitude towards him, this kind of threatening posture towards him, which is a generic threat that's not premised on what you're going to say. It's your participation in the commission at all is going to result in us coming after you in the way that we're threatening you to do so. So all I'm saying is that let's imagine a world where Mr. Karim comes in front of you and there's someone out there who thinks that he's going to say something about him. But then he comes in front of you, doesn't say anything about them, right? That person then they don't know what he's going to say, but they might be the one who's threatening him even before he says it, before he comes here. So that's the dilemma that my client is faced in, and that's why, Chair, I can adopt what you say to me regarding who these people potentially are, but I'm just emphasizing that the way in which these threats come about in terms of the timing shows how serious they are, that they're making these threats even before he comes here and says anything. So I understand what you say, it's just that I have a slightly different view on that exact same proposition.
Thank you, Mr. Premier.
Thank you, Chair.
Thank you.